All rise.
That's your case. Which I think was the case referred to by Lady Hale before each member of the court. It was a court in which she sat, as indeed did my Lord Phillips. The case was about, those of members of the court who are not familiar with it, as indeed I wasn't this morning, the case was about a complaint by two mothers in prison against the rule applied by the prison service with fairly extreme rigidity that a baby could not remain with her mother above the age of 18 months. And what was in very bold summary held was that the prison service was entitled to have a policy, but it was not entitled to operate it in the rigid fashion which the prison service then did. The result was that one of the two complainants succeeded and the other failed. The principles are set out, that were applied in that case, are set out principally in the judgment of the court at paragraphs 78 and 103 to 105, simply summarising those aspects that may, unless I've overlooked something, and I have only had a short time to look at it. But first of all, it seems that the public interest questions essentially revolve around two competing considerations. One was the prevention of disorder in prison, which had traditionally been the main reason for applying restrictions of some kind on the right of mothers in prison to retain their babies with them. And the other was, in the language of Article 8.2, the rights of others, and in particular, the rights of children. The point was made by Lady Hale at, I think, paragraph 78, thereabouts, by reference, 79, forgive me, by reference to an earlier decision of the Court of Appeal in which she had also sat, W and B children, that Article 8 considerations would enter into the sentencing process, and in particular, the way in which you should dispose of a case in which a pregnant mother or a mother with a very small child was before the court. The only respect in which we would take issue with any of the analysis here, of course the context was very different, is that at paragraph 115 in the judgment of the court, there is a reference to the question whether the evidence before us in QB's case, that was the child, is sufficient to suggest that this might be such an exceptional case as to justify a departure from the policy. Now, I don't wish to focus undue attention on an aspect of the matter which was not primarily an issue, but I respectfully doubt whether the Strasbourg court would have approached the issue here by asking whether a sufficiently exceptional case was made out, as opposed to simply weighing the competing policies. But otherwise, there does not appear to be anything in this judgment that we would quarrel with. It's perhaps worth making the point in general terms that in the jurisprudence of the Strasbourg court, the Article 8 provisions the Strasbourg court has certainly rejected the suggestion that prisons are, so to speak, an area in inverted commas where ordinary human rights are not allowed to enter, although they have recognised that the punitive purpose of imprisonment is such that you have to ask yourself how much is necessary to achieve that result and whether particular prison rules are going too far. The main respects in which Article 8 considerations can enter into penal policy in that respect are, first of all, in the area of mitigation, which is clearly a mitigation factor if you have certain family relationships, and very powerful indeed if it involves a very small child, where you have the independent interest of the child to consider. Secondly, Article 8 considerations, and indeed other provisions of the Convention, may enter into it when you examine the actual conditions in prison. The principal case in which the Strasbourg Court has had to consider that is Makotta, which was about visiting rights. But it's not a principle confined to visiting rights, as is demonstrated by the insemination case at Dixon, which for a quite different purpose I'll be referring to shortly. I hope that helps, and I hope that in the short time available I haven't omitted anything which may be thought significant. Now, I had referred the court to the four...
I'm terribly sorry. I mean, just before we leave this in that particular paragraph, an exceptional case is to justify departure from the policy. I mean, can't you have a policy that... a policy is only, I think I said very recently, a policy is simply an indication of how you propose to exercise a discretion.
Yes.
Can't you say, we've got a policy of honouring extradition agreements?
Yes.
And therefore, that is going to be, in general terms, the way that we deal with extradition cases. We will extradite. Of course, there will be exceptions, and an exception will be if Article 8 is if Article 8 is infringed without sufficient justification.
Yes, but I mean, your Lordship describes that as an exception, but we don't have a policy of honouring extradition treaties. We have a policy of honouring extradition treaties in cases where Article 87 does not apply, in cases where there are no convention rights that would be infringed. And that is both because of the language of the statute and because of the language of the treaty, which in the case of the 72 Treaty expressly accepts that. In my submission, the problem about approaching the matter in that way is that it involves starting out with a presumption which is simply inappropriate. I mean, I don't deny that proper weight has got to be attributed to the public interest considerations within Article 8.2 that underlie extradition. And I don't deny that if you look back retrospectively over the course of a number of cases of this sort, assuming that there were to be a number of them, you would no doubt find that most of them had failed. What I take issue with is the suggestion that one should factor the failure of most of them into the actual decision-making process of an individual case by saying, what's so special about this? I mean, the case law which we'll be coming to, which deals with policies, it in fact makes it pretty clear that a policy which sets an exceptional circumstances barrier in terms has on quite a number of occasions been held not to be compliant by the Strasbourg Court. For example, in the case about digital records of DNA of persons arrested, there was a policy there which was subject to an exceptional circumstances proviso. That was one of the factors that made it difficult to accept. In Dixon, the position was exactly the same. That involved an administrative policy, which precisely because it was operated by the prison service in a manner which required demonstration of exceptional circumstances, was not thought sufficiently to answer the requirements of Article 8.
You say you're not allowed a policy, you're not allowed a presumption.
No.
You've got to start from an absolutely on an even playing field, and you've got to look at the what individual purpose would be served, A, by extraditing, and what individual hardship and so forth, damage to family and private rights would be caused in each individual case.
I certainly say much of that. I wouldn't adopt as my own submission the entirety of the way that your lordship puts it, and particularly not your lordship's open words. I don't say that you're not entitled to have a policy. And I respectfully suggest that looking at the thing on an even field basis is apt to be misconstrued. I don't think your lordship meant it this way, as being that you do not necessarily attach strong weight to any particular factor that goes into the balance. I have always accepted that the underlying policy behind extradition, so far as it serves the public interest in preventing crime, is an important policy, and you're entitled to go into the balancing exercise with conscious of its importance. What you are not entitled to do is to say that because it is an important policy, there has got to be something extremely special about a particular case for an Article 8 right to prevail. And one doesn't find any presumption of that kind in the way in which the Strasbourg court has approached the matter. You do occasionally find it in domestic courts, as you have done traditionally in the French jurisprudence. And that is actually the crux of the difference in a case like Belgiudi between the way in which it was approached in Paris and in Strasbourg.
The difficulty is that, I mean, if it is an important, weighty factor, you're allowed to say that, but you can't go on to say, and therefore it's difficult in the normal case to find a countervailing factor which will outweigh it.
Well, there are 2 points here. First of all, when you say it's an important factor, you've got to ask yourself, is it an important factor in the particular case? Are the particular facts of this case such as to engage the policy in a way that would give rise to damage to the public interest if it were not adhered to?
Well, you may be right that there may be some crimes where you can say, well, this is a complete one-off and we can forget about it, but most criminal offences, and the present alleged offence is surely an example, one would say automatically that there was a general public interest in their being pursued.
Yes, but the question is that how strong is the public interest in this case? I think you can say that in all cases there will be a public interest in its being pursued. It's an important public interest, but the strength of the public interest in a particular case will vary from one case to the next. All that I'm saying is that you have to look at how strong it is in the particular case, and then look at how great the damage to the Article 8 right would be, in the specific case.
Doesn't Strasbourg, in fact, say that locking up criminals is a very important thing to do? Article 5, the exception to Article 5, it doesn't introduce proportionality at all.
No.
Provided you've been sentenced to a term of imprisonment by a lawful court, that's the answer to a claim under Article 5. That's going to very seriously interfere with your family life as a side wind. But Strasbourg says, never mind, if this is what you're doing, locking up somebody who's been convicted of a crime, fine. Now, we're not quite in this case, into somebody being convicted of a crime. It's the stage before. But nonetheless, we are surely in an area to which Strasbourg or the Convention applies great importance, in contradistinction to deporting somebody, where you don't find that in the Convention.
Well, first of all, the Article 5 limitations, or the Article 5 exceptions are different from those in Article 8 and, on the whole, very much stronger. But secondly, your Lordship's formulation to me can't be strictly true, because if it was, there would be no scope, for example, for taking Article 3 into account, which is one context in which there is an almost universal consensus that imprisonment in circumstances which, by the objective standards applied by the Convention, would involve maltreatment is not to be tolerated, notwithstanding that it may be the norm for the country in question. Moreover, if your Lordship's formulation was true without qualification, it would be very difficult to justify the very many cases in which prisoners, in the United Kingdom in particular, have been held to have been wrongly deprived of aspects of their family and private life. Now, in all of these cases, the starting point, of course, is that he brought it upon himself by committing crimes which made it just to imprison him. It was nevertheless the case that the court asked itself, how far is it necessary not just to imprison him, but to deprive him of these aspects of his family life, the right to correspond without having his letters opened by the prison governor's service, in Dixon, the right to artificial insemination facilities, in Makota, the right to visiting rights. And these are rights which the prison services generally, certainly in Western European countries, endeavour to preserve as a matter of policy, and whose disappearance would involve, or could certainly involve, a quite serious breach of the Convention, notwithstanding that they have in the past been regarded as the normal consequences of committing serious crimes. So I'm unable to accept your Lordship's formulation without quite a lot of qualification. We'll run right back into the debate that we're having. What one has seen in all the 4 criminal deportation cases, Mustaqim at paragraph 43, El Judi at paragraphs 62 and 74, Bultif at paragraph 46, Unyar at paragraph 54, is the constant reiteration of the test that it has got to be necessary for the purpose of satisfying a pressing social need. Now, I referred this morning in answer to a question from my Lord Mance to handicide, and that is a case that is found in volume 3 of the authorities bundle at tab 38.
One of the findings that the pressing social need in the deportation cases is what exactly? Is it the risk of repetition of offending by the person who's to be deported?
That has generally been the context in which it's been factually
yes.
analysed.
Well, that's my impression. And if you put it that way, it becomes a very individualised exercise of looking at the interference with the individual's family life on the one hand and his propensity to continue offending on the other.
Yes.
And these may be paradigm cases for that kind of thing. But at the moment, I'm still struggling to see whether that is an exact match for what we're dealing with in an extradition case. And I'm drawn back to Lord Brown's idea of one having a policy, which, as it were, is an extra element which one has to take it.
The policy can only be relevant so far as it's a policy for the prevention of crime.
Yes, of course.
And in response to your Lordship, I would say that I agree that approach involves a highly specific, fact-specific approach to these questions. But that is not only exactly what, in practice, the Strasbourg Court has done, but it is what it has commended as the correct approach, in particular in Mustaqim, where your Lordship may remember the paragraph which said one's not looking at the importance of the policy as a policy in the abstract. One is looking at the importance of applying the policy in the particular case, and at what applying it in the particular case would contribute to whichever is the relevant public interest identified in Article 8.2.
I interrupted you. We were going to look at handicide then.
Yes, handicide was not an Article 8 case. It was the Little Red Schoolbook case, and it was about Article 10. But it is the origin of the expression necessary to answer a pressing social need, which subsequently appears consistently in the Article 8 jurisprudence and indeed in the jurisprudence on some other articles of the Convention. I think that if your Lordships, my lady, turn to Volume 3, tab 38 one can go straight to the relevant paragraph without any further consideration of the actual detailed circumstances of this particular case. But at paragraph 48 in the judgment of the court, the report says this: the court points out that the machinery of protection established by the Convention is subsidiary to national systems safeguarding human rights. The Convention leaves to each contracting state in the first place the task of securing the rights and freedoms it enshrines. The institutions created by it make their own contribution to this task, but they become involved through contentious proceedings and once all domestic remedies have been exhausted. These observations apply notably to Article 10.2. In particular, it is not possible to find in the domestic law of the various contracting states a uniform European conception of morals. The view taken by their respective laws of the requirements of morals varies from time to time and from place to place, especially in our area, which is characterized by a rapid and far-reaching evolution in opinion. By reason of their direct and continuous contact with the vital forces in their countries, state authorities are in principle in a better position than the international judge to give an opinion on the exact content of these requirements, as well as on the necessity of a restriction or penalty intended to meet them. The court notes at this juncture that whilst the adjective necessary within the meaning of Article 10.2 is not synonymous with indispensable, neither has it the flexibility of such expressions as admissible, ordinary, useful, reasonable, or desirable. Nevertheless, it is for national authorities to make the initial assessment of the reality of the pressing social need implied by the notion of necessity in this context. That is the origin, as a matter of history, of this expression in the subsequent case law. It, of course, was in the context of a consideration of the extent of the margin of discretion, and also in the context of an area where, namely censorship, where values are much more widely dispersed across Europe than they are in the context of deportation or extradition. But it reflects the broader principle that public policy exceptions to convention rights fall to be narrowly construed and narrowly applied. Now, I ought to point out, since I've referred to the French domestic jurisprudence arising out of these Strasbourg decisions, that the French Conseil d'État has not, in fact, adopted the same approach in extradition cases. As we have pointed out in our printed case, the Conseil d'État still appears to apply in extradition cases a principle corresponding to the Tuami principle applied in deportation cases before Del Giudi. There are many cases on the subject, but the leading one is generally regarded as a case called De Deus Pinto, and if the court would take volume 4 of the authorities volume, at flag 59, the relevant paragraph of the French text is at the bottom of page 2, and 2 pages further on is the English translation. Whereas, if this was an extradition case, whereas if the challenged decree is likely to adversely affect the right of the applicant to respect his family life guaranteed by Article 8 of the European Convention for the Protection of Human Rights and Fundamental Freedoms, this measure, in principle, is justified by the nature of the extradition procedure, which allows, in the interest of public policy, and under the conditions set by the provisions governing them, both the judgment of persons living in France who are prosecuted abroad for crimes and offences committed outside France, and also the enforcement by the same people of criminal convictions pronounced against them abroad for such crimes or offences. The relevant expression there is justified by the nature of the extradition procedure, or in the French, which is somewhat pithier, that cette mesure trouve en principe sa justification dans la nature même de la procédure d'extradition. Now, that effectively is saying that extradition is self-justifying the consequent disruption of family life is simply one of those things that is inherent in the administration of the criminal law. The problem is that the result of that approach is to marginalize or suppress entirely the open-minded assessment of proportionality which is required by the Convention. The same formula has been used in other cases where extradition was resisted in France on Article 8 grounds right up to this year. Now that does not, with respect, appear to be consistent with the Strasbourg Court case law on the deportation of convicted criminals, which is based on substantially the same public interest in the prevention of crime, nor is it consistent with the case law in both Strasbourg and the United Kingdom, which treats forcible removal in either category as calling for the same approach, albeit that the particular facts may differ as between those categories. Now, of course, this court is not sitting on appeal from the principles applied by the Conseil d'État, which will in due course have to square this particular circle for itself, doubtless in a case like this one. The question is bound to arise under the framework decision for the European arrest warrant, because the insertion of humanitarian exceptions to extradition is extremely common in many extradition treaties, in particular French ones, and the only scope for giving effect to them under the European arrest warrant framework decision is the general reservation that appears in the framework decision for the Human Rights Convention. That is the only way in which they can be given effect. Now, for present purposes, it's perhaps enough to point out that the French courts have greater freedom to take that line under their domestic law than the English ones. The reason for that appears to be that although in France treaties have prevailed over other sources of domestic law for some time, the tension between extradition and convention rights is approached as a potential conflict between different treaty obligations, i.e. a conflict between two co-equal sources of law between which it is necessary to choose. And what seems to have happened in France is that the French appear to have given precedence to the Human Rights Convention in cases engaging Articles 2 and 3, but not, at any rate so far, in other cases. The position of the United Kingdom is a good deal more straightforward because of the statutory priority accorded by Section 87 to the accused's convention rights, and because of the exception in the 1972 treaty for cases where extradition is contrary to the law of the requested state.
Just going back to Diaz Pinto, I noticed that that was a case where the applicant had been convicted, 6-year sentence, and his name suggests maybe that he was a Portuguese rather than a French citizen.
Or Brazilian.
Or Brazilian, yeah.
Yes, that's a less reliable assumption nowadays than it used to be. A large proportion of the population of Portugal being currently resident in Paris. But your lordship may be right.
Yes, but you refer to other cases, and it looks as it's a general statement of principle, regardless of whether you've fled a country in which you've been convicted or where you're awaiting trial.
Between those two, and it's undoubtedly a general statement of principle, because exactly the same phrase has been used in the recital of reasons in successive extradition cases in France. My own researches in the website of the Conseil d'État go up to earlier this year, and the same formula is used. Now, it appears to be a matter which is far more open in France than it would be here, precisely because one's looking at a conflict between treaty obligations and not with a situation where the Human Rights Convention prevails over other domestic law considerations. I can, without actually taking the court to it, just refer briefly for your note to Volume 4, Tab 69, which is an extremely interesting article. I cite it simply by way of background, save for one point which I will make, which goes to this very issue that your lordship had raised with me. It's an article by Mr. Roger Herrera. Mr. Herrera is a former conseiller d'État. He was, in fact, the juge rapporteur in the Belgiacem case, and he is widely regarded as the leading authority on French extradition and deportation law. This article concerns the interface between international human rights obligations in particular and French domestic extradition law. If the court is minded in due course to delve into this article, may I first of all identify the pages which seem most directly relevant. They are in the French pagination, which is shown in the English translation. Pages 733, 742 to 4.
Sorry, 730?
733.
Yep.
742 to 4. And 747. Now, I should point out that at page 744, there is an observation about the principle which I have just referred to by reference to Deus Pinto. It's at the in page 744 in the reference to the French text, which appears in the English translation. Starts with 3 bullet points, if the court has that. Then over the following page, the last section before page 745, there's a 4th bullet point, tab 69. Regarding Article 8.1, the legal precedent of the Conseil d'État may be summarized as follows. An extradition decree may infringe the law on respect for family life. This measure, in principle, is justified by the very nature of extradition proceedings to allow, in the interest of public policy and other lawful conditions, persons living in France to be judged and subjected to proceedings abroad for offences committed outside France and the execution of criminal penalties pronounced against them abroad for such offences. And then there's a sentence which says, this legal precedent is similar to that of the European Commission on Human Rights. The court ought to be aware that the cases cited in the footnote do not appear to support the suggestion that the European Commission has ever stated any such principle. The nearest they get to it is Launder, which is a case I shall come to in a moment. It is not referred to, but I won't take up time by referring to it. But at tabs 80 to 81 in volume 5 of the authorities bundle, the court will find the cases referred to by Mr. Herrera at note 40. They are both decisions of the Commission. The first is an extradition case which raises no issue under Article 8 at all. It's about the lawfulness of detention pending extradition proceedings under Article 5. The second is a very old decision of the Commission, 1977, about the German provisions for deporting convicted aliens, in which the complaint was that the law, instead of staying a deportation order while it was placed before the administrative tribunals, required the complainant to remain outside Germany during the 3 months or so that his appeal was being considered by the administrative tribunal. Neither of them appear to have anything to do with the issues with which the court is presently concerned. Now, I want at this stage, if I may, to turn to the 4th chapter in the agenda which I sketched out at the outset this morning, which relates to exceptional circumstances, whether as a legal or a practical requirement. It's common ground on this appeal that exceptional circumstances are not required as a matter of law in order to support a case that extradition is incompatible with Article 8. It was, as the court has seen, the divisional court's view, but one would still approach the facts with a strong expectation that they won't be good enough unless they are exceptional. There is one Strasbourg authority which lends support to that view, and that is Launder, a decision of the Commission, not the court, on admissibility, which was decided in 1998. That case will be found in volume 3 of the authorities at flag 42. This was a case which arose out of the extradition from the United Kingdom of an accused person to Hong Kong to face charges of corruption. At page 7 of the printout of the Commission's decision, this was a majority decision of the Commission, about two-thirds of the way down the page, the Commission finds that the applicant's extradition would amount to an interference with his family life, it being common ground that his wife currently lives in the United Kingdom. However, it appears undisputed that the decision to extradite the applicant complied with the formal requirements of UK law. As regards the applicant's claim that his extradition some 19 years after the alleged offences would be contrary to legal certainty, and that the court's approach to the issue of the passage of time was not reasonably foreseeable, the Commission has already found that when examining whether extradition should be allowed, the decisions of the domestic courts were neither arbitrary nor unreasonable. Furthermore, the Commission finds that the decision to extradite the applicant has a legitimate aim, namely the prevention of disorder or crime. As regards the question whether the interference was necessary, the Commission recalls that the notion of necessity implies a pressing social need and requires that the interference at issue be proportionate to the legitimate aim pursued. The Commission considers that it is only in exceptional circumstances that the extradition of a person to face trial on charges of serious offences committed in the requesting state would be held to be an unjustified or disproportionate interference with the right to respect for family life. The Commission finds that in the present case, no such circumstances have been shown to exist. And they go on to deal with the reasons and the circumstances of that case. Now, that decision has the merit, from my learned friend Mr. Perry's point of view, of being an extradition case, but it is a majority decision of the Commission at a relatively early stage of the development of Strasbourg jurisprudence in this area, and it is not easy to reconcile it with subsequent case law. The more recent case law of the Court itself has decisively rejected the approach of looking for exceptional circumstances before giving effect to a convention right, particularly under Article 8, that conflicts with some national legislative policy.
But, I thought you said earlier, and perhaps I picked you up incorrectly, that there is no decision by the Strasbourg Court.
There is no decision by the Court on extradition. In an Article 8 and extradition. There are, of course, decisions of the Strasbourg Court on other articles, notably Article 3, but not on Article 8 and extradition. There is the Launder decision by the Commission. What it is possible to say is that the whole concept of exceptional circumstances as part of an underlying policy has been examined, particularly in the context of Article 8, by the Strasbourg Court on at least 3 occasions in the last 2 years. And the effect of those decisions is that the approach of looking for exceptional circumstances gets in the way of the fact-specific nature of the proportionality assessment. And that has been justified in cases that disclose 2 main strands of reasoning. First of all, it has been said that it is not consistent with the primacy of convention rights to require exceptional circumstances before they can prevail over an inconsistent public interest, as the Court will have seen this morning. In the Bell-Judy case, in the Commission's decision, the exceptional circumstances may be relatively easy to find, but they are required the other way round. The second line of reasoning, which I suppose is related to the first, is that any assessment of proportionality requires a proper weighing up of the individual against the public interest, which is seriously inhibited if you throw a 6-pound lead weight into the public side of the scales at the outset of the proceedings. Now, the 3 cases are Dixon, McCann, and S against the United Kingdom. They were all petitions from the United Kingdom in cases where the decision-maker had directed himself that something special was required, either because the law required him to direct himself in that way, or because there was an established administrative policy to that effect. Dixon is at tab 36 of Bundle 3. that was about access by long-term prisoners to artificial insemination facilities.
Sorry, which tab again?
Tab 36.
Go.
Now, the circumstances in this case were that the Secretary of State had a written policy about the making available of artificial insemination facilities to prisoners. The policy was that he would not make such facilities available except in exceptional circumstances. If the court would turn to page 2 of the printout, paragraph 13 of the recital of the facts, the relevant bit of the policy is quoted. In a letter dated the 28th of May, the Secretary of State refused the complainant's application. He first set out his general policy. Requests for artificial insemination by prisoners are carefully considered on individual merit and will only be granted in exceptional circumstances. Now, the reasoning, the policy was held to be non-compliant in this case, and the reasoning in the relevant respect is at paragraphs 82 and following. Paragraph 82, however, paragraph 81 recites the European consensus that conjugal visits should, subject to a variety of different restrictions, be made available to prisoners. And paragraph 82 goes on to say this, however, and even assuming that the judgment of the Court of Appeal in the Mellor case amounted to judicial consideration of the policy under Article 8, the Court considers that the policy as structured effectively excluded any real weighing of the competing individual and public interests and prevented the required assessment of the proportionality of a restriction in any individual case. That basically sets out what I've described as the second strand of the reasoning, that it interferes with the fact-specific nature of the inquiry. In particular, and having regard to the judgment of Lord Phillips MR in the Mellor case and of Lord Justice Auld in the present case, the policy placed an inordinately high exceptionality burden on the applicants when requesting artificial insemination facilities. They had to demonstrate in the first place as a condition precedent to
the application of the policy.
That the deprivation of artificial insemination facilities might prevent conception altogether, the starting point. Secondly, and of even greater significance, they had to go on to demonstrate that the circumstances of their case were exceptional within the meaning of the remaining criteria of the policy, the finishing point. The Court considers that even if the applicant's Article 8 complaint was before the Secretary of State and the Court of Appeal, the policy set the threshold so high against them from the outset that it did not allow a balancing of the competing individual and public interests and a proportionality test by the Secretary of State or by the domestic courts in their case as required by the Convention. In addition, there is no evidence that when fixing the policy, the Secretary of State sought to weigh the relevant competing individual and public interests or to assess the proportionality of the restriction. Further, since the policy was not embodied in primary legislation, the various competing interests were never weighed, nor were issues of proportionality ever assessed by Parliament. Indeed, the policy was adopted, as noted in the judgment of the Court of Appeal in the Mellor case, prior to the incorporation of the Convention into domestic law. The policy may not amount to a blanket ban, such as was at issue in the Hurst case, since in principle any prisoner could apply, and as demonstrated by the statistics submitted by the government, 3 couples did so successfully. Whatever the precise reason for the dearth of applications for such facilities and the refusal of the majority of the few requests maintained, the Court does not consider that the statistics provided by the government undermine the above finding that the policy did not permit the required proportionality assessment in an individual case. Neither was it persuasive to argue, as the government did, that the starting point of exceptionality was reasonable, since only a few persons would be affected, implying as it did the possibility of justifying the restriction on the applicant's convention rights by the minimal number of persons adversely affected. The Court therefore finds that the absence of such an assessment, as regards a matter of significant importance for the applicants, must be seen as falling outside any acceptable margin of appreciation, so that a fair balance was not struck between the competing and private and public interests involved. There has accordingly been a violation of Article 8 of the Convention. Now, I should point out in this case, if the Court would go back to paragraph 82, that Mr. Dixon's particular problem was not the starting point. He actually satisfied the starting point. He fell foul of the finishing point, which was where the exceptionality criteria came in, and it was the exceptionality criterion that meant that the policy did not comply with Article 8 of the Convention, because it involved a general presumption necessarily based on the importance of the relevant policy as a matter of general principle, which immediately took one away from the fact-specific exercise concentrating on the particular features of the individual case. Now, McCann is at tab 44 in the same bundle, and in some respects the issue here was similar. It was whether the decision of a local authority to evict Mr. McCann from his council flat could be challenged under Article 8. Now, in this particular case, what had happened was that Mr. McCann occupied a council flat together with his partner. His partner left him and terminated the tenancy, and the local authority then sought to evict Mr. McCann. Now, in this case, the requirement of exceptional circumstances arose from two previous decisions of the House of Lords in two cases involved called Kazi and Harrow Borough Council and King and Lambeth Borough Council. The details don't matter, but essentially what those cases had held was that although as a public authority exercising a statutory function, the landlord's eviction decisions had to satisfy a proportionality test, the fact that the landlord had an absolute proprietary and contractual right to possession would be conclusive unless the circumstances were quite exceptional. That was the law as the House of Lords had declared it. The cases have been cited at note 19 of our printed case, if the Court wishes to go into the landlord and tenant aspects of that. The European Court's reasons for upholding the complaint under Article 8 are at paragraphs 48 and 49, and a bit later at paragraph 52. Paragraph 48 is at page 11 of the printout. The Court considers that this interference was in accordance with the law and pursued the legitimate aim of protecting the rights and freedoms of others in two respects. First, it protected the local authority's right to regain possession of the property as against an individual who had no contractual or other right to be there. The domestic courts laid considerable emphasis on this aspect, which applies equally to all landlords who are trying to repossess property. However, the interference also pursued the aim of ensuring that the statutory scheme for housing provision was properly applied. The others in such a case are the intended beneficiaries of the complex arrangements set up, among others, by the Housing Acts. That's a reference to the local authority waiting lists. The Court accepts that it is only by limiting the protection of the Acts to the categories to which it applies that the policy underlying the Acts can sensibly be implemented. The essential question in this case is, therefore, whether the interference was proportionate to the aim pursued and thus necessary in a democratic society. Now, I think one can then go over the page to pick up the reasoning after a recital of the arguments and certain of the facts. Paragraph 52. In the present case, however, the local authority chose to bypass the statutory scheme by requesting Mrs. McCann to sign a common law notice to quit, the effect of which was immediately to terminate the applicant's right to remain in the house. It does not appear that the authority, in the course of this procedure, gave any consideration to the applicant's right to respect for his home. Moreover, under domestic law, in summary proceedings such as those brought against the applicant, it was not open to the county court to consider any issue concerning the proportionality of the possession order, save in exceptional cases, whereas the Court of Appeal put it in the present case, something has happened since the service of the notice to quit, which has fundamentally altered the rights and wrongs of the proposed eviction. No such exceptional circumstances applied in the present case. Furthermore, although since the applicant's landlord was a public authority, it was open to him to challenge the decision to obtain the notice to quit and bring possession proceedings in an application for judicial review, his application failed because the local authority had not acted unlawfully. Now, of course, the context there is very different from the one with which the court is presently concerned. On the other hand, what you have here is a situation where, as a matter of English legal policy, the landlord, although a public authority, had an absolute contractual and proprietary right of possession. And what had happened was that the House of Lords had held that that is such a strong indicator in favour of allowing it possession as against the person holding over, that very exceptional circumstances would be required before you could displace it. That whole approach was regarded as inconsistent with the approach required by the Convention. Now, the third and last case on this
subject, I think, to a blast, perhaps that's too colloquial a description, in a subsequent House of Lords case. I
Yes.
think there's an extensive examination of this decision in Lord Scott's speech.
Well, I think it can fairly be described as a blast, actually.
Possibly it is worth just looking at paragraph 54. In McCann.
The Court does not accept that the grant of the right to the occupier to raise an issue under Article 8 would have serious consequences for the functioning of the system or for the domestic law of landlord and tenant. As the minority observed, it would only be in very exceptional cases that an applicant would succeed in raising an arguable case, which would require a court to examine the issue. In the great majority of cases, an order for possession could continue to be made in summary proceedings. Well,
We're talking about a distinction here between a legal test of exceptionality and an in-practice test of exception, or an in-practice result of exceptionality.
well, I'm not sure that one is, because if that had been the relevant distinction, then there should have been no difficulty in the Home Office in justifying its position in Dixon, where there was no legislation and no judicial decision involved, but simply an administrative policy.
I'm not making a comment about Dixon, I'm making a comment
I can see that, but I respectfully doubt whether they are in fact making the distinction between a legal and a factual test. No doubt they are saying, in most cases it will be found that the complainant fails. And that is something that I acknowledged at the outset of my submissions. What I object to is the insertion of this presumption as part of the process of reasoning, which leads to his failure in this instance. And that, in my submission, is not acceptable.
So they're using it there to cut off the floodgates complaint, aren't they? And
Well, certainly. I mean, I recognise that there are problems about any way of going about this, if I can use the most neutral expression that I can contrive, which leads to most extradition cases, at any rate by family men, failing. And that I'm not contending that that is likely to be the result. And the reason it's not likely to be the result is that I recognise, as I suspect was what the Court was endeavouring to emphasise at paragraph 54, that the policy involved here is an important policy. But one is concerned not with its importance in the abstract, but with its importance as applied to these facts. Now, S and the United Kingdom is the celebrated and topical case about the refusal of the police to delete computerized records of DNA samples taken from arrested suspects who were not subsequently convicted of any criminal offence. Now, as in Dixon, there was no legal requirement for exceptional circumstances before a computer record could be deleted. Such a requirement was, however, applied in practice because it was part of the guidelines drawn up by the Association of Chief Police Officers, which in practice police forces complied with. The policy was held to contravene Article 8 for a number of reasons, many of which have no analogies with the present case, but one of them was simply that exceptionality set the bar too high. The report of the case will be found at flag 49 in Bundle 3. The policy, so far as relevant, was set out at page 7 of the printout by reference to the ACPO guidelines. A set of guidelines for the retention of fingerprint and DNA information is contained in the retention guidelines for nominal records on the Police National Computer, drawn up by the Association of Chief Police Officers. The guidelines are based on a format of restricting access to the Police National Computer data rather than the deletion of data. The guidelines set out various degrees of access. I think one can then go straight to paragraph 35. Chief Police Officers are the data controllers of all PNC records created by their force. They have the discretion in exceptional circumstances to authorise the deletion of any conviction penalty notice for disorder, acquittal or arrest histories owned by them. An exceptional case procedure to assist chief officers in relation to the exercise of this discretion is set out in Appendix 2. It is suggested that exceptional cases are rare by definition and include those where the original arrest or sampling was unlawful or where it is established beyond doubt that no offence existed. Now, in its reasoning, the Strasbourg Court began by pointing out, as I have done today, that the proportionality assessment cannot be carried out by asking whether the retention of DNA data is justifiable as a general principle. It has to be justified in the particular case, and that one finds at paragraph 105 and 6 on page 20 of the printout. The court finds it to be beyond dispute that the fight against crime, and in particular against organised crime and terrorism, which is one of the challenges faced by today's European societies, depends to a great extent on the use of modern scientific techniques of investigation and identification. The techniques of DNA analysis were acknowledged by the Council of Europe more than 15 years ago as offering advantages to the criminal justice system. Nor is it disputed that member states have since that time made rapid and marked progress in using DNA information in the determination of innocence or guilt. However, while it recognises the importance of such information in the detection of crime, the court must delimit the scope of its examination. The question is not whether the retention of fingerprints, cellular samples and DNA profiles may in general be regarded as justified under the Convention. The only issue to be considered by the court is whether the retention of the fingerprint and DNA data of the applicants as persons who have been suspected but not convicted of certain criminal offences was justified under Article 8, Paragraph 2 of the Convention. And when there has exactly the same distinction made as in Mustaqim between weighing up the importance of the policy as a policy and weighing up the consequences of its application in the particular case, only the latter being appropriate as part of the proportionality review. Now, after reviewing the material for police work and concluding that the value of this material was high, the court then dealt with proportionality on the opposite page at paragraph 118. The question, however, remains whether such retention is proportionate and strikes a fair balance between the competing public and private interests. In this respect, the court is struck by the blanket and indiscriminate nature of the power of retention in England and Wales. The material may be retained irrespective of the nature or gravity of the offence with which the individual was originally suspected, or of the age of the suspected offender, fingerprints and samples may be taken and retained from a person of any age arrested in connection with a recordable offence, which includes minor or non-imprisonable offences. The retention is not time-limited, the material is retained indefinitely. There exist only limited possibilities for an acquitted individual to have the data removed from the nationwide database or the materials destroyed. In particular, there is no provision for independent review of the justification for the retention according to defined criteria, including such factors as the seriousness of the offence, previous arrests, and the strength of suspicion against the person and any other exceptional circumstances. Now, what was held was that the ACPO policy was incompatible with Article 8. And essentially that was because it was not tailored to the individual case, but was, for the reasons given in that last paragraph, a general policy adopted in the interests of efficient policing, which could only be justified by looking at the weight to be attached to the general principle of efficient policing and not to the particular circumstances of the complainant's case. And that is why one finds the conclusion at paragraph 125, the court finds that the blanket and indiscriminate nature of the powers of retention of the fingerprints, cellular samples and DNA profiles of persons suspected but not convicted of offences, as applied to the case of the present applicants, fails to strike a fair balance between the competing public and private interests, and that the respondent state has overstepped any acceptable margin of appreciation in this regard. Accordingly, the retention at issue constitutes a disproportionate interference with the applicant's right to respect for private life and cannot be regarded as necessary in a democratic society. This conclusion obviates the need for the court to consider the applicant's criticism relating to the adequacy of safeguards. Now,
could you go back, I'm sorry to interrupt you again, to 119, the latter part of it, particularly the last 4 lines talking about no provision for independent review and so on.
Yes.
Is that a relevant factor in this case? I mean, everyone knows that the extradition process is one which has a series of opportunities for review of various kinds, and we don't need to go into the details. I mean, just in general terms, is that something that can be brought into account in striking the balance? Because one's dealing not with just the fact of sending somebody abroad, but one's looking at the system which allows for that to be done.
well, the difficulty I have with those 4 lines is that ordinarily, as the House of Lords has remarked more than once, the Strasbourg Court and the English courts exercising the same function do not apply a review of the procedural adequacy of the process by which the result was reached, but simply whether the answer was acceptable in accordance with the convention. And that those 4 lines appear to suggest, although they're clearly not the main ground of decision, that it would make a difference if there were some form of independent review. If the independent review existed but arrived at a conclusion inconsistent in the court's own view with the appropriate balance, then it would make no difference.
Well, I understand that point, but I mean, it does fit in with the adjectives blanket and indiscriminate.
Yes, it does.
If it's a thing which simply the police do what they want and keep it forever and ever, that you can describe that as blanket and indiscriminate.
Indeed.
And we're not dealing with that kind of thing here, are we? I mean, extradition, to an extent, is person-specific because the individual has a right to put his case before the court and the Secretary of State and so on.
Well, we are not dealing with that here, but we are dealing with a process of reasoning, particularly in the divisional court, which is not wholly person-specific, because, and the same point is reflected in some of the questions that the court has put to me in the course of today, because what one is not entitled to do is to say, this is a very important policy. It's therefore a policy which we should not depart from, save in exceptional circumstances. And the exceptional circumstances don't exist, therefore the complaint fails. Now that is essentially the process of reasoning that I'm attacking. And this is one of a number of cases that indicate that that is not the correct approach. It's not the correct approach because it involves weighing the importance of the policy in general rather than the consequences of its application in the particular case.
But Mr. Humphrey, I'm curious. I mean, you're not suggesting as a result of S's that in the future every single person whose DNA has been taken is going to have a right to judge, have his individual case judged, are you? I mean, they're going to have to evolve new criteria, but the new criteria are simply going to have to be more specific and give more weight to the fact that in the case of those suspected but not convicted, you can't hang on to the stuff as long and so forth.
Well, the new criteria would have to, if they are going to apply generally, would have to make very elaborate provision for some of the factors that were relevant in this case, the age of the offender, for example, and others that were not relevant in this case but might be relevant. But, my Lord, I do say that to have a policy which precludes the exercise of a proportionality assessment in an individual case, however inconvenient, is not consistent with Article 8 of the Convention. I do say that. And now, the policy can be sufficiently elaborate to cater for a very large number of variations between individual cases, and one could then perhaps apply it mechanically. But it would have to be very elaborate indeed, and to anticipate all the individual circumstances that might be relevant in order to pass muster. A policy is not a permissible alternative to an assessment of proportionality once the relevant convention right is engaged. And the whole of the Strasbourg jurisprudence supports that approach.
I mean, isn't there some premium put on consistency and predictability and all these other sort of factors that ordinarily are intended to weigh? I mean, how in your extradition world are people going to be treated similarly?
Well, if you can imagine two identical cases, it's actually not easy to imagine that would ever be so, but sufficiently similar cases would, in a rational system of the administration of justice, be treated similarly. I would accept that. But there are two ways of treating people similarly. You can either look at their individual cases and see whether they justify a particular taking of the balance, or you can apply a rule that dispenses yourself from looking at individual cases and substitutes a general blanket rule. Now, the latter is simply not acceptable as a way of dealing with rights under Article 8.1 when they are engaged, as they were in this case.
We're coming to Huang later, are we?
Yes.
We'll look at paragraph 16, which I remind myself deals with known rules and so forth.
Yes.
I wonder where this is taking us, because looking at the respondent's case, there doesn't seem to be anything between you on the whole. On pages 3 to 5,
well,
it's only whether the court below properly applied what you both agree to be the law.
Well, that is quite right. But this court is not the prisoner of counsel's consensus, and I do feel that I have to present a coherent submission as to what the law is, even if it involves occasionally agreeing with Mr. Perry. There is no issue between us on Huang, for example. Now, it is true, and this is the background to Huang, that at one stage the House of Lords appeared to endorse an approach of looking for exceptional circumstances before upholding objections to deportation based on Article 8. But it is also true that even before Dixon, McCann and S in the United Kingdom overtly rejected the concept of blanket rules and exceptionality, the House of Lords had recanted essentially on the grounds that the approach was simply not consistent with the way that the proportionality exercise needed to be carried out. Now, Huang is in flag 14 at volume 1, the authorities volume.
I don't think Lord William would say that he recanted. I think he would say that he made the world was always
That would have been a more diplomatic... Yes. That would have been a more diplomatic way of putting it. Those members of the bar who previously misinterpreted what William had recanted. tab 14, my Lord Brown refers to paragraph 16, and this is which does deal with the relevance of general policy. The authority will wish to consider and weigh all that tells in favour of the refusal of leave which is challenged, with particular reference to the justification under Article 8.2. There will in almost any case be certain general considerations to bear in mind. The general administrative desirability of applying known rules if a system of immigration control is to be workable, predictable, consistent and fair, as between one applicant and another, and damage to the good administration and effective control if a system is perceived by applicants internationally to be unduly porous, unpredictable or perfunctory, the need to discourage non-nationals admitted to the country temporarily from believing that they can commit serious crimes and yet be allowed to remain, the need to discourage fraud, deception and deliberate breaches of the law, and so on. In some cases, much more particular reasons will be relied on to justify refusal, and some examples are given of that. The giving of weight, this is just above letter F, to factors such as these is not, in our opinion, aptly described as deference. It is performance of the ordinary judicial task of weighing up the competing considerations on each side and according appropriate weight to the judgment of a person with responsibility for the given subject matter and access to special sources of knowledge and advice. Now, if I may take up the point that Madam Brown based on this, I have no problem, as far as my submissions are concerned, with the relevance of the considerations set out in the first half of that paragraph. That is because they are plainly relevant to the efficacy of the policy, which in this case was the economic interests of the country in question, this being an ordinary immigration case. And one can see that if one is entitled to have such a system, one is entitled to have an orderly system which is reasonably consistent and reasonably predictable. But none of that in my submission touches the submission that I am making, because it is not implicit in my submission that because every case has got to be judged on its own facts, every case is going to end up with a variety of irreconcilable results. One would expect the job to be done properly, and there to be a general consistency of approach, bearing in mind variations called for by the circumstances of the particular case. Now, the main point for which I cite Huang is the one that is dealt with between paragraphs 18 and 20, which deals with the question of exceptionality. Starting just above letter F, on page 186 of the report, it is unnecessary for present purposes to attempt to summarize the Convention jurisprudence on Article 8, save to record that the article imposes on member states not only a negative duty to refrain from unjustified interference with a person's right to respect for his or her family, but also a positive duty to show respect for it. The reported cases are of value in showing where, in many different factual situations, the Strasbourg Court, as the ultimate guardian of Convention rights, has drawn the line, thus guiding national authorities in making their own decisions. But the main importance of the case law is in illuminating the core values which Article 8 exists to protect. This is not perhaps hard to recognize. Human beings are social animals, they depend on others. Their family or extended family is the group on which many people most heavily depend, socially, emotionally, and often financially. There comes a point at which, for some, prolonged and unavoidable separation from this group seriously inhibits their ability to live full and fulfilling lives. Matters such as the age, health, and vulnerability of the applicant, the closeness and previous history of the family, the applicant's dependence on the financial and emotional support of the family, the prevailing cultural tradition, and the conditions in the country of origin, and many other factors may all be relevant. The Strasbourg Court has repeatedly recognized the general right of states to control the entry and residence of non-nationals, and repeatedly acknowledged that the Convention confers no rights on individuals or families to choose where they prefer to live. In most cases where the applicants complain of a violation of their Article 8 rights, in a case where the impugned decision is authorized by law for a legitimate object, and the interference or lack of respect is of sufficient seriousness to engage the operation of Article 8, the crucial question is likely to be whether the interference or lack of respect complained of is proportionate to the legitimate end sought to be achieved. Proportionality is a subject of such importance as to require separate treatment. And then taking this up at just below letter D, after citing the famous Privy Council decision in De Freitas, this formulation has been widely cited and applied, but counsel for the applicants, with the support of liberty and a valuable written intervention, suggested that the formulation was deficient in omitting reference to an overriding requirement which featured in the judgment of Chief Justice Dixon in Oakes, from which this approach to proportionality derives. This feature is the need to balance the interests of society with those of individuals and groups. This is indeed an aspect which should never be overlooked. The House recognised as much in Rasgar, when having suggested a series of questions which an adjudicator would have to ask and answer in deciding a convention question. It said that the judgment on proportionality must always involve striking a fair balance between the rights of the individual and the interests of the community, which is inherent in the whole of the convention. The severity and consequences of the interference will call for a careful assessment at this stage. If, as counsel suggested, insufficient attention has been paid to this requirement, the failure should be made good. In an Article 8 case where this question is reached, the ultimate question for the appellants, the Appellate Immigration Authority, is whether the refusal of leave to enter or remain in circumstances where the life of the family cannot be reasonably expected to be enjoyed elsewhere, taking full account of all considerations weighing in favour of the refusal, prejudices the family life of the applicant in a manner sufficiently serious to amount to a breach of the fundamental right protected by Article 8. If the answer to this question is in the affirmative, the refusal is unlawful, and the authority must so decide. It is not necessary that the Appellate Immigration Authority, directing itself along the lines indicated in this opinion, need ask in addition whether the case meets a test of exceptionality. The suggestion that it should is based on an observation of Lord Bingham in Rasgar. He was there expressing an expectation shared with the Immigration Appeal Tribunal that the number of claimants not covered by the rules and supplementary directions but entitled to succeed under Article 8 would be a small minority. That is still his expectation, but he was not purporting to lay down a legal test. And one should perhaps, while this case is open, just look at paragraph 12. Sorry, no, I'm getting it's 12 of the next case.
Well, just before we leave this one, I mean, would it be all right for the district judge to say, only in a very small minority of cases will an Article 8 defence to extradition and extradition application succeed? This isn't one of them.
No.
Why?
Because what that involves doing is, instead of simply observing, as it were in hindsight, that most cases fail, that is simply an expectation about how many of these cases will succeed, what the district judge would be doing in your lordship's scenario is bringing that expectation into the decision-making process itself. He would be saying, not only when one looks back on it does one find that most cases fail, but I am going to approach this case on the basis that this one is in principle likely to fail unless there's something very special about it. Now, it's when one moves to that latter proposition, as I think your lordship did in his formulation.
Well, he can put it in late in his judgment, but not early on.
No. When he retires, he can say, most of these cases decided on correct grounds, of course, failed, but I looked at each one on its specific merits, and he would have reason to be proud of himself. Now, that is essentially the difference between an expectation and a presumption. And the presumption is not acceptable.
If he went through the facts of all the cases, the ones which failed and the ones which succeeded, then he would be able to see whether there was anything similar between the facts of this case and the facts of either of those groups.
It would certainly be acceptable if there were cases that were literally indistinguishable in every relevant respect to look at those.
Yes.
In many contexts, in a decision of this sort involving the weighing up of different factors, the courts have deprecated an approach which simply involves going through previous instances, making the relevant adjustments, and, so to speak, scoring them under each head.
And the difficulty is you don't get any feel for the way in which, for what have been regarded as relevant factors taking cases outside the majority and into the minority.
Well, you will not necessarily get a feel for it, but I suspect that there will be some factors that emerge as particularly significant. After all, that is what Bultif did. It listed a number of factors which, without seeking to be exhaustive, were regarded as likely to be relevant and important.
What is the justification in a foreign case that entitles one to say, in this case I've got to look for a serious risk of a flagrant breach?
Well, in a foreign case, the justification for that, as it has always been put, is that if you are dealing with something whose adverse effects on the convention right arises entirely from that which is done by somebody who has a state with no obligations under the convention, you need a higher threshold, because the Strasbourg court recognizes that those who have no obligations under the convention, who are not party to it, have a much wider range of actions must be regarded as acceptable in the eyes of those who are party to the convention. It is the difference that justifies that approach is entirely a matter of the difference between what happens beyond the territorial ambit of the convention and what happens within it. In a foreign case, you need much more extreme facts coming close to barbarity, to justify saying you would not do anything with your own nationals which involved allowing somebody else to do that to them. Clearly, that kind of approach is not as easily justified in cases where one is dealing with something that we may not regard as acceptable here, but is within the range of acceptable conduct for other countries. But that's the way that it is rationalised. I would accept what I think is implicit in your Lordship's question, that it is untidy. But tidiness has never been, and rightly never been, a particular virtue in this area.
And again, Strasbourg adopts an exceptionality approach in cases of sex discrimination. But there, what's got to be exceptional is the justification.
Yes, well, in general, Strasbourg adopts the approach that the justification has got to be exceptional, and the court will have seen that approach expressly adopted by the Commission in Belgiudi.
Mr. Sumption, beyond saying that it's a fact-specific decision, can this court give any guidance to those who have to operate the extradition process about how to exercise their judgment?
Well, within appropriate limits, yes. Now,
what limits?
You're going to ask me what are the appropriate limits.
Yes.
The difficulty is it has got to do it in a way which does not hinder the assessment of cases in which the relevant factors may be more important than they are in other cases. In other words, there's absolutely nothing wrong with doing something like what the Strasbourg court did in Bultif and the Grand Chamber did in Unia, where they set out a number of factors that will frequently be entitled to considerable weight. One should not say that they always will be, because there will be cases where some of them are not entitled to so much weight. Equally, it would be difficult to say that certain factors are completely irrelevant, except, of course, those that don't come within the relevant policy justification at all, because in this case, for instance, they don't relate to the prevention of crime.
Paragraph 16 is perhaps of some help, because Lord Bingham is giving some idea of what he describes as the general considerations to bear in mind.
Yes.
And they're put in fairly broad terms, but it does strike me, looking at these, that these are constants. they will apply with a suitable adaptation of wording. If one was trying to construct a list of factors which are appropriate in extradition cases, there will be a list on one side of the balance of things that will be common to extradition cases.
Yes.
Is that not right? And
there will.
And one might legitimately say these are factors to which careful regard must be paid, and so on. Appropriate weight must be attached to them. You can give all those kinds of hints, but you've got these general factors on the one hand, and you've got the individual specific factors relating to the applicant, or the appellant, I should say, in this case, and the nature of the behaviour that's in issue on the other.
Yes.
So that's broadly how it's going to play out, isn't it? You've got a pile of general things, and you've got the specific things on the other side.
And the significance of the general things, of course, will also vary with the individual case. Nothing in my submissions is intended to exclude that kind of guidance. In fact, Lord Bingham himself put it more or less exactly in that way in EB, Kosovo and the Home Secretary, which is a case where somewhat similar questions arose. If your lordships and my lady would turn to tab 9 and just look at paragraph 12 of this speech, Lord Bingham has just set out the essence of his own analysis at paragraphs 8, 18, 19 and 20 of Huang, and taking the analysis up at paragraph 12, he says, thus the appellate immigration authority must make its own judgment, and that judgment will be strongly influenced by the particular facts and circumstances of the particular case. The authority will, of course, take note of factors which have or have not weighed with the Strasbourg Court. It will, for example, recognise that it will rarely be proportionate to uphold an order for the removal of a spouse if there is a close and genuine bond with the other spouse, and that spouse cannot reasonably be expected to follow the removed spouse to the country of removal, or if the effect of the order is to sever a genuine and subsisting relationship between parent and child. But cases will not ordinarily raise such stark choices, and there is in general no alternative to making a careful, informed evaluation of the facts of the particular case. The search for a hard-edged or bright-line rule to be applied to the generality of cases is incompatible with the difficult evaluative exercise which Article 8 requires. Now, that in our submission is absolutely what we submit. Now,
I mean, I'm sorry, where's our 2003 Act again?
It's in volume 4 at flag 61.
I mean, this approach involves a dramatically different approach to section 87 from what was the equivalent to the Gomez case that we were looking at a few months ago? Is there an equivalent to that here?
Which bar was being considered in that case?
Section 82.
That was a Section 82 case.
82?
Yes. That was, yes, the passage of time.
Yeah.
That, of course, is not a provision which is new to the 2003 Act.
Yeah, absolutely. But I mean, nobody seems to doubt that in an 82 case, you can talk in terms of exceptionality. I mean, I don't know if we use that expression. I don't think we did, but we said it'd be very difficult to establish something.
Yes, that is so, but the reason for that, and there are actually, Section 82 is one of a number of provisions that refers to injustice or oppression. Another example which has given rise to a lot of case law being Section 91, which refers to its being unjust or oppressive to extradite the person by virtue of his physical or mental condition. But in all of these injustice and oppression cases, first of all, the court is not concerned with a balancing of a prima facie right against an exception, a policy-based exception, which is the essence of the Article 8 exercise. And secondly, it is fair to say that the requirement that it should be unjust or oppressive is setting a very exacting test, a much more exacting test than the balancing exercise involved in an Article 8 proportionality assessment. I don't think that anything that I am submitting would involve altering the basis on which the courts approach the unjust and oppressive provisions of the 2003 Act.
Is that new? Is 91 new? I mean,
No, 91 was also in the previous extradition acts.
okay.
Not in exactly the same form, but there was a... But Mr. Perry says he doesn't think that it was. I had thought that it was, but I will check that.
It was up to the Home Secretary to deal with these matters, wasn't it?
Yes.
As in the famous case.
Well, many of the matters, part of the purpose of the 2003 Act was to transfer to the courts many of the functions which the Home Secretary either alone dealt with or had a concurrent jurisdiction to deal with. And I think that was one of them, but I'd better check it in view of Mr. Perry's doubts. Now, we would adopt the summary given by Lord Justice Sedley not long after Huang was decided in AG Eritrea. That your lordships and my lady will find in bundle 1 of the authorities bundle. It's a passage quoted by the Divisional Court in its judgment, although I respectfully submit that they didn't actually respect what Lord Justice Sedley was saying.
Tab 1.
This is tab 1 of volume 1, paragraph 25. And paragraph 31, after dealing with Huang, Lord Justice Sedley said, the effect of their lordship's decision, and if we may say so, the intended effect of this court's decision in Huang, has thus not been to introduce a new interpretation of Article 8, but to clarify and reiterate a well-understood one, while its practical effect is likely to be that removal is only exceptionally found to be disproportionate. It sets no formal test of exceptionality and raises no hurdles beyond those contained in the article itself. And at paragraph 31, we respectfully adopt and follow this reasoning. That's a reference to Lord Justice Carnworth's judgment in Makaka. We respectfully adopt and follow this reasoning, but because it did not prevent counsel for the Home Secretary and MT, or in the instant case, from reverting to a test of exceptionality as a surrogate for the Article 8 decision, we think it necessary to reiterate that there is no such legal test. The fact that in the great majority of cases the demands of immigration control are likely to make removal proportionate and so compatible with Article 8 is a consequence, not a precondition of the statutory exercise. No doubt in this sense, successful Article 8 claims will be the exception rather than the rule, but to treat exceptionality as the yardstick of success is to confuse effect with cause. Now, in our submission, that is right, and it is the reason why one should not bring a view that most cases will fail into the actual process of deciding the proportionality of the facts in a particular case. Now, we have pointed out at paragraph 3 of our printed case, and I won't take court to the materials, that by and large the change represented by Huang has been welcomed by commentators as bringing English law into line with the practice of the Strasbourg Court. Both of the articles which we have cited there, however, make the point that even in the short time which had elapsed between the decision in Huang and the writing of the articles, there were signs of the reappearance of exceptionality in another guise. And that is a comment that has proved to be prophetic. Huang was decided in February 2007. There have been a number of decisions since Huang in which the discredited legal requirement of exceptional circumstances has simply reappeared as a factual presumption. Now, in our printed case at paragraph 37, there is a mistake in that we cite the divisional court decision in Birmingham as one of the aberrant decisions. It was in fact decided before Huang under the law as it had previously been understood wrongly to be.
Paragraph which?
Paragraph 37 of our printed case. Our strictures against Birmingham are not justified because it was decided before the House of Lords decided Huang. Now, the principal post-Huang decisions reintroducing the exceptionality test as a rule of practice have been the divisional court's decisions in Jeso, Lopez and Hernandez in December 2007, some 10 months after Huang, and the later decision in April 2008 in Tajik. Now, if I may just take the court to those two cases, in Jeso, Lopez and Hernandez, the complaint of the appellants was that if extradited to Spain, they would be held for a period of 5 days incommunicado in police custody before they were brought before a court. And that was said to be a contravention of a number of articles of the Convention, including Article 8. The case is to be found in Volume 1, Tab 16. I should actually mention that in some cases the court has been supplied with the original transcript of the judgment. In those cases we have put the reported version into Volume 5, but we can refer to paragraphs without difficulty. The Jeso case was a case of, among other things, Article 8, based on this period of incommunicado detention in Spain. The main problem, in fact, about the appellant's case in Jeso was that even assuming that they would be held incommunicado by the Spanish police, the difficulty was that any effect on their private or family life would result entirely from the way in which they were treated while in Spain. The actual extradition was not relied upon as breaking up their family life. So it was a pure foreign case in the Ullah-Razgar classification, and therefore called for a much higher threshold test before Article 8 could be said to be engaged at all. The argument, in fact, in this case was rejected on the particular facts. The court held that there was no likelihood of the appellants being held incommunicado, but there were two observations about it in principle which clearly influenced the divisional court in our case. They will be found in Lord Justice Dyson's judgment at paragraphs 56 and 57. After dealing with various other grounds of complaint, he turns to Article 8. The district judge held that even if the appellants were subject to incommunicado detention and prison dispersal, they had not established a case of wholly exceptional circumstances which could be held to be an unjustified or disproportionate interference with their Article 8 rights. I refer to the prison dispersal policy at paragraphs 59 and 61 below. The reference to exceptional circumstances is derived from Launder and the United Kingdom, an extradition case, and from Birmingham, where Lord Justice Laws said that the execution of a properly constituted extradition could be resisted on Article 8 grounds only where a wholly exceptional case was shown to justify a finding that the extradition would on the particular facts be disproportionate to its legitimate aim. As I have said in Ullah, Lord Bingham said that the difficulty facing an applicant will be no less where he is relying on Article 8 than where he is relying on Articles 5 and 6. Ullah was an Article 9 case. Article 8 was directly in play in Razgar. In Huang, the House of Lords said that in an immigration case, a fair balance must be struck between the rights of the individual and the interests of the community. There was no test of exceptionality, but there was an expectation that the number of claimants not covered by the rules and supplementary directions but entitled to succeed under Article 8 would be a small minority. Mr. Gordon submits that the district judge was in error in applying an exceptionality test. I agree that it is not right to apply such a test as a formula for proportionality. So much is made clear by Huang. He then quotes Lord Justice Sedley. The same applies in relation to extradition, What is required is that the court should decide whether the interference with a person's right to respect for his private, or as the case may be, family life, which would result from his extradition, is proportionate to the legitimate aim of honouring extradition treaties with other states. It is clear that great weight should be accorded to the legitimate aim of honouring extradition treaties made with other states. Thus, although it is wrong to apply an exceptionality test, in an extradition case there will have to be striking and unusual facts to lead to the conclusion that it is disproportionate to interfere with an extraditee's Article 8 rights. The appellants do not rely on any right to private or family life acquired in England. Well, he then sets out the facts and the issue disclosed by them. Now, in our submission, that passage is effectively paying lip service to Huang and the proportionality assessment in the way that it is actually carried out by the Strasbourg court. Its effect is simply to substitute for a test of exceptionality a search for striking and unusual facts. And that, in our submission, is not consistent with the case law either in Strasbourg or in the United Kingdom.
I'm sorry, I mean, if that's a foreign case, as you say, I mean, I don't understand what all this is about anyway.
Well, my Lord, it's clear that this part of the judgment is not... The Article 8 point didn't in fact arise, so this was obiter twice over. One, it's a foreign case, and two, there was a finding that there was no reason to suppose that he would be kept incommunicado. So this is a dictum in which the application of Article 8 in domestic cases is being considered on the admittedly erroneous assumption that was the relevant question. For all that, this particular dictum has been extremely influential, and it was followed in the subsequent case of Tajik, which the court will find in Volume 2 at tab 27. Mr. Tajik was sought to be extradited to the United States to meet a charge of smuggling arms out of the United States to Iran. He opposed his extradition.
This is in tab...
it's at tab 27.
27.
And it's a judgment of the Divisional Court given by Lord Justice Richards.
Yeah.
Mr. Tajik was accused of arms smuggling contrary to US law. He opposed his extradition on a large number of grounds, the least of which appears to have been Article 8. Lord Justice Richards in the Divisional Court summarised the facts relied upon at paragraph 152 of the judgment under the heading Convention Rights. The final issue is whether the district judge ought to have ordered Tajik's discharge under Section 87 of the 2003 Act on the ground that his extradition would not be compatible with his convention rights, in particular his Article 8 right to respect for his private and family life. And the facts of his particular case are set out, and Mr. Jones's rhetorical question is then set out at the end of that paragraph. If Article 8 doesn't apply to these facts, in what case would it apply? The district judge found that there was nothing exceptional about his circumstances to make extradition disproportionate under Article 8.2, and that the possibility that he could be prosecuted in the United Kingdom did not amount to an exceptional circumstance. And his reason for rejecting that argument appears at paragraph 156. For my part, I am satisfied not only that the district judge would have reached the same conclusion had she applied the test in JSO, but also that she would have been right to do so. I have reached the same conclusion applying the test in JSO to the facts of the case. It is true that the interference with Tajik's Article 8 rights will be substantial, but in my view it is proportionate to the legitimate aim of honouring the United Kingdom's extradition treaty with the United States. Even if Tajik could be prosecuted in the United Kingdom, the existence of that possibility would not render extradition disproportionate. What is said in JSO about the need for striking and unusual facts to lead to the conclusion that extradition would be disproportionate does not constitute a separate legal test, but recognises the practical reality that Article 8 will rarely provide a ground for refusing extradition. I do not accept, however, that the facts of this case are sufficiently striking or unusual, or that Mr. Jones is justified in suggesting by his rhetorical question that Article 8 must provide a ground for refusing extradition in this case, if it is ever to do so. Now, those two cases between them effectively treat striking and unusual facts, the phrase used in JSO, as constituting the new test, and in our submission, it is indistinguishable from the old one. Now, that was very much the approach adopted by the Divisional Court here. I've already referred to the Court to paragraphs 21 and 22 of the Divisional Court judgment, which is the section that encapsulates the reasoning that I am criticising. Now, in my submission, that passage is wrong for three related reasons. First of all,
Sorry, can I just find the passage?
Yes, of course. It's paragraphs 21 and 22.
Thank you.
In flag 3 of the appendix. I'm sorry, my lord.
It's the second half of paragraph 22 you're going to, is it?
That is the absolutely critical
That's
part.
the critical bit, yeah.
Yes, but to get the context of the reasoning, one perhaps needs to go back to paragraph 21. But in our submission, it is wrong for a number of reasons. First of all, like Lord Justice Dyson in JSO, Lord Justice Laws is importing into the proportionality assessment itself a presumption that in extradition cases, Article 8 challenges will fail. And that being the norm which serves as the court's point of departure, Lord Justice Laws goes on to ask himself, what is there to take this case out of the norm and cause it to deviate from the presumed outcome? In our submission, that is not an approach which has ever been acceptable to the Strasbourg Court or indeed the House of Lords. Secondly, Lord Justice Laws was with respect wrong to say that the public interest in extradition will always be very substantial. I would agree.
The public interest in
extradition will always be very substantial. It will usually be very substantial. How substantial must depend on an examination of, for example, the seriousness of the offences and an assessment of the damage, if any, that will be done to the relevant public interest if he's not extradited. But a blanket rule is not appropriate. Thirdly,
the damage that will be done
if he is not extradited, you have to look at what, if any, damage will be done in this particular case to the public interest, rather than approach it on the basis that one is looking at the importance of the principle in general, and that will always be very considerable.
How do you judge the damage that will be done in an individual case by not?
Well, it's the whole basis.
Of course, you know that this particular man won't stand trial, as the Americans would like him to do. But I mean, the overall impact on the whole process of extradition, how on earth do you judge that?
Well, one significant factor, but not the only one, would be the importance or the gravity of the allegation against the accused person, for example. Now, that's one of the Bultieff factors. Now, if one's going to do that, why is one doing that? One is doing it, I would suggest, because it is one measure of the importance of deporting or extraditing this particular individual on these facts. And there are other factors that may also be relevant.
Not sure I've really grasped the point. Is it that you this case will not be setting a precedent? Is that the kind of reasoning, or
No. One is looking at the deterrent value for the prevention of crime of extradition in a particular case. Now, that factor may be more or less important depending on the nature of the charge and its gravity. I will say something about the application of these principles to the present case in due course. At the moment, I can't put it more specifically than that.
But you're not allowed to say, if I follow the other part of the argument, this is a very, very unusual case. The offence is not one likely to be repeated, and so on and so forth. You can't take that kind of thing.
You can certainly say the second part of that, and indeed in a number of the Strasbourg cases.
Anything in your favour?
No. What you can't say is this is justified because it is an exceptional case, because that is simply reintroducing exceptionality, not simply as a survey of the way most of these cases go, but as part of the process of decision-making.
I interrupted. You've got a third related point.
Yes, Lord Justice Law's choice of authorities with which to support his reasoning is, in our submission, both revealing of his approach and difficult to support. He refers in this context to Launder, Jaso, and Tajik. Launder was the commission case to which I've already referred, which does apply a test of exceptionality, but in my submission has been superseded by authoritative decisions both of the European Court of Human Rights and the House of Lords. Tajik and Jaso can be taken together. They were cases which adopt the striking and unusual facts case test. The result, of course, may well have been right, indeed almost certainly was right, in both Jaso and Tajik. But I have submitted that the test was not right. Now, I should point out, while we are on Tajik, that at paragraph 21 of Lord Justice Law's judgment, he refers to takes a quotation from Tajik, in practice a high threshold has to be reached. That is, in fact, not something that appears in Lord Justice Richard's analysis of the Article 8 argument. It is derived from that part of Lord Justice Richard's judgment which is concerned with section 91. It comes from paragraph 108 of Tajik. Can you remind me where Tajik is? Taking out the reference.
Volume 27.
Sorry? Tab 27 in volume 2. The quotation taken by Lord Justice Laws comes from paragraph 108, where the learned judge is dealing with the argument that was raised in Tajik about section 91. Section 91, as the court has seen, is concerned with cases where it would be unjust or oppressive to extradite the accused by reason of his physical or mental condition. That involves a quite different test. It's concerned exclusively with the accused's health. And unless the accused's health is such as to make him manifestly unfit to stand trial, it will normally be a complete answer to a case based on section 91 that the facilities available to him in the requesting state are at least as good as those available to him in England, or at least adequate. By comparison, Article 8 is concerned not with his state of health as such, but with the impact of extradition on his family life, his ability to function as a social being. Now, his state of health, physical and mental, may be one factor in that, but it's a far wider test. And the fact, of course, that the accused will receive suitable medical treatment in prison in the foreign jurisdiction is no answer to the disruption of his family life. Mr. Tajik's own facts were that he claimed to be suffering from a serious heart condition. There appears in the facts to have been some doubt as to how serious it really was. But all that Lord Justice Richards is saying at paragraph 108 is that a person's physical or mental condition has got to be both serious and untreatable in the requesting state before it can really be said to be unjust or oppressive in the natural meaning of those words, to extradite him for that reason alone. Now, my lords, the final point of principle before turning to the facts of this case concerns delay. The circumstances in which delay may be relevant to an Article 8 challenge to the removal of the complainant from the United Kingdom were considered by the House of Lords in EB Kosovo, a case I have already referred to for the general principle set out by Lord Bingham at paragraph 12 of his judgment. The main question at issue in EB Kosovo, and the case is at tab 9 of volume 1, the main question at issue was what, if any, bearing delay on the part of the immigration authorities had on the proportionality of deporting the complainants. The principal speech was given by Lord Bingham, with which the rest of the committee agreed, subject to one point on which a different view was taken by my Lord Brown, and the relevant part of the speeches, which I think is self-contained for this purpose, is at paragraphs 14 to 16, where Lord Bingham identified three categories of delay. It does not, however, he says, follow that delay in the decision-making process is necessarily irrelevant to the decision. It may, depending on the facts, be relevant in any one of three ways. First, the applicant may, during the period of any delay, develop closer personal and social ties and establish deeper roots in the community than he could have shown earlier. The longer the period of delay, the likelier that is to be true. To the extent that it is true, the applicant's claim under Article 8 will necessarily be strengthened. It is unnecessary to elaborate this point, since the Secretary of State accepts it. Delay may be relevant in a second, less obvious way. An immigrant without leave to enter or remain is in a very precarious situation, liable to be removed at any time. Any relationship into which such an applicant enters is likely to be initially tentative, being entered into under the shadow of severance by administrative order. This is the more true where the other party to the relationship is aware of the applicant's precarious position. This has been treated as relevant to the quality of the relationship. Thus, in Adjo, it was noted that it was reasonable to expect that both the applicant and her husband would be aware of her precarious immigration status. This reflects the Strasbourg Court's listing of factors relevant to proportionality of removing an immigrant convicted of crime, whether the spouse knew about the offence at the time when he or she entered into a family relationship, Bultief. A relationship so entered may well be imbued with a sense of impermanence, but if months pass without a decision to remove being made, and months become years, and year succeeds year, it is to be expected that this sense of impermanence will fade, and the expectation will grow that if the authorities had intended to remove the applicant, they would have taken steps to do so. This result depends on no legal doctrine, but on an understanding of how, in some cases, minds may work, and it may affect the proportionality of removal. Delay may be relevant, thirdly, in reducing the weight otherwise to be accorded to the requirements of firm and fair immigration control, if the delay is shown to be the result of a dysfunctional system which yields unpredictable, inconsistent, and unfair outcomes. In the present case, the applicant's cousin, who entered the country and applied for asylum at the same time, and whose position is not said to be materially different, was granted exceptional leave to remain during the 2-year period which it took the Secretary of State to correct his erroneous decision to refuse the applicant's application on the ground of non-compliance. In JL, heard by the Court of Appeal at the same time as the present case, there was a somewhat similar pattern of facts. JL escaped from Sierra Leone with her half-brother in 1999 and claimed asylum. In 2000, her claim was refused on the grounds of non-compliance. As in the applicant's case, this decision was erroneous, as the Secretary of State recognised 18 months later. In February 2006, the half-brother was granted humanitarian protection. She was not. The system so operated cannot be said to be predictable, consistent and fair between one applicant and another, or as yielding consistency of treatment between one aspiring immigrant and another. To the extent that this is shown to be so, it may have a bearing on the proportionality of removal or of requiring an applicant to apply from outside the country. So Lord Bingham identified 3 ways in which delay might be relevant. 1, the complainant might have formed closer family ties during the period of delay. 2, it may have led the complainant and his family to a false sense of security that he would not in fact be deported. And 3, it may suggest that the decision-making process was dysfunctional and thereby diminish the weight of any public interest in the decision being upheld. And that last point was the one doubted by my Lord Brown. I rather doubt whether Lord Bingham was seeking to lay down exhaustive categories of relevant delay. The essential point is that the facts relied upon to establish a case under Article 8 may be significantly strengthened if coupled with delay. Now, my Lords, that may strike the Court as a convenient point at which to break. The next topic is the facts, and that will not take me long to deal with. Would it assist if I were to say whereabouts the main evidence on that point is to be found, in case there's a desire to do some homework?
Tab numbers would be very helpful.
Yes, I think it would.
Right. Well, in the core volume, the evidence is to be found in witness statements that appear from tab 18 onwards. 18 to 23 are the factual witness statements, and 24 to 32 are the medical witness statements, just to apply some measure of selection to those. The critical statements are the 2 statements of Mrs. Norris, which are in tabs 19 and 22. As far as the physical health of Ian Norris is concerned, I suggest that the Court goes straight to the latest of the medical statements, which resumes the previous history. You will also, I suspect, find it helpful to look at tab 24, which is a chronology of events relevant to Ian Norris's health, which was put before the lower courts. Finally, on Mrs. Norris's position, there are a number of reports, but I would suggest that you go directly to the report of Professor Kopelman, which is the latest of them, which recites much of the past history in a way that makes a detailed examination of the other ones less significant. And Professor Kopelman is at tab 32.
Can you just tell me where, if at all, we can find the closing memorandum on law, which you put before the district judge and on which he comments at the end of his judgment?
I don't think that it is
Nor
in
do I,
the
but
bundles, but
have you got it?
I will produce it.
Thank you.